So, welcome back to the Utsav Mukherjee IP and Tech Law Show. It's been a long time, and I'm excited to welcome you back to the show. Today, we are going to talk about something which is very interesting in the current times and is also something which is very, very valuable for anyone who is working in the domain of AI or who is running an AI business or who is creating content through AI. So, we're going to talk about the ownership of copyright in AI generated content, right? So a lot of creators today, even tech companies, even businesses are creating or leveraging content that is made originally through AI. Now, traditionally, when we talk about copyright, so copyright is just basically the right that any creator has in any artistic work, right? So a musician when they create music, or a writer when they write a book, or say like a poet who makes a poem, anything that is creative, that is artistic, the creator automatically gets copyright in that, right? But today, a lot of this creative content is created with the help of AI. So now the question arises: who owns the copyright to such content? Is it the AI itself, the AI company, or is it the person who feeds the prompts in the AI, that is the creator, or is it nobody? And what is actually the originality of that content, right? Because that content is created through pre-existing sources, data that is already out there. So a lot of questions about copyright arise, right? Now, there is no very simple, straightforward, clear-cut answer to these questions. But what we can do is we could look at the emerging legal position across jurisdictions, across countries. And there's four main countries that I'm going to focus on today. One is my home jurisdiction, India. The other is China. Then there is USA, and there is UK. So we're going to look at the laws and the judgments that are coming up in these countries on copyright and AI generated content. So first of all, let's talk about India. What is the legal position in India on AI generated content? So, the Copyright Act in India says that the author of a creative work is the person who causes the work to be created, right? And since this Copyright Act was actually made in the year 1963, for obvious reasons, there was no mention of copyright and AI generated content. So now, under copyright law in India or even in other countries, there is a concept called derivative work. What is a derivative work? Derivative work is simply something that is created by deriving elements from another pre-existing original work, right? Something which is created by using existing sources, but not as a carbon. It is not really a obvious copy of that. So, for example, if I read a book and then I write a new book which is derived from that original book with some elements from that, but with a newer plot, with new elements, and I can show that there is some element of creativity, originality, that would be considered a derivative work. So the Supreme Court in the Eastern Book Company versus DB Modak case has in India held that a derivative work has copyright in it. The creator of a derivative work has copyright as long as there is some element of originality and it is not created without any application of mind, right? So now if we look at the developments with this principle with respect to what is happening with copyright in AI in India. So there was an interesting case where the an application was filed before the Copyright Office in India for copyright in Raghav AI, and the copyright application was filed for the right in the AI generated work to be given not only to the human author but also to that AI app called Raghav AI. And surprisingly, the Copyright Office had originally given that go ahead and given the AI, that is Raghav AI, copyright in the work that was created by it along with the human author. But then later this was overturned, and the Copyright Office went back on this decision and just removed the AI's name from the authorship. But more recently, there is an AI activist by the name of Mr. Stephen Thaler who applied for copyright to be granted to his AI system called Tabas for an artwork that was created by it before the Copyright Office in India. And he has filed similar applications for copyright ownership to be given to the AI app itself in at least 16 other countries as well. And he then approached later the Delhi High Court to direct the Copyright Office to quickly decide this matter, right, of giving copyright to Dabas. And the High Court has given the Copyright Office a time of 8 weeks to decide on whether copyright can be given to the AI system itself. So this is something which is still pending. and there is no clarity on the exact position of whether an AI app itself can have authorship on AI generated content in India. The position is a little bit murky. If we look at the principles on derivative works, then the human author who has created that work using AI to create a modified work which is not a carbon copy of the original can have a copyright. But whether or not the AI app will also have ownership is slightly controversial or mixed position. There's no clear answer on that yet as far as India is concerned. So now that we move on to other jurisdictions, let's come to USA. So in USA, the Supreme Court has made its position very, very clear, right? And this too was in a case filed by Mr. Stephen Thaler, the same activist that I referred to in the context of India, where he again asked for copyright to be given to an AI system for a work generated purely by AI, right? And he had first applied before the Copyright Office in the US, which rejected his application. And so he went in appeal. He appealed this decision before the courts, in the US, and he went all the way to the Supreme Court. And the Supreme Court refused to intervene, right? So the Supreme Court said that we don't want to interfere with the Copyright Office's decision. And the position as far as USA is concerned is that there can only be human authorship in AI generated content, and AI itself can never be considered an author, right? Now coming to the United Kingdom, they have taken a relatively more liberal stance on AI, right? So in the UK, the statute on copyright actually recognizes the author of any computer generated work as the person who makes the arrangements necessary for the creation of the work, right? And this provision existed long before AI was ever in the picture. So the law in UK was actually way ahead of its time, right? And a common and popular reading of the legal provisions in the UK is that whoever makes the prompts in the AI is the author of the AI created work. And past judgments on similar subject matters, although not AI, also lean in this direction that if you're using computer to make any kind of content or any kind of creative work, then that work, there can be copyright in that work, right? So although it does not say something on whether, it doesn't say that the AI app is the author, but it basically says that AI generated work can be considered eligible for copyright. That is very clear in the UK, right? So now that we have done USA and the UK, let's come to the most interesting jurisdiction with respect to AI and copyright, which is China. So Chinese courts have held in more than one ruling that content generated by AI is eligible for copyright. And they have said that such AI generated works must have elements of originality. But what is even more interesting is that they have granted copyright to works created by persons through minimal prompting in AI, right? So even if the output is created by modification of pre-existing content, it would still be eligible for copyright. And even if the level of prompting by the human being is very low, there will still be copyright in that AI generated work. So now that we have compared the position across countries, where do you think that the challenges exactly are in AI generated content? First of all, there are multiple contributors to any AI generated work. One is the AI app itself, right? Then there is a human prompter. And the third would be the various sources and data that the AI app is using to create that new content. So if you look at the terms and conditions of any AI app, they typically thrust both ownership and liability for content generated through them on the human prompter, right? And another major issue is that most countries still do not have dedicated laws for AI. And a lot of courts are determining copyright issues in AI on the basis of old statutes and judgments. So I would say, to summarize, the overall current legal position on copyright and AI generated content would be that the more the human creativity and application of mind or prompting there is, the stronger copyright there can be, whichever jurisdiction you're talking about, right? And purely AI generated output stands on a weaker footing. It's more likely to be infringing, it's more likely to not stand the threshold of originality required for copyright to be there. And the risks of infringement are just a lot higher, right? So now what are the solutions? I've told you about the challenges, I've told you about the legal position in different jurisdictions. Now what is the solution? How do we ensure that the content being created by AI is eligible for copyright, and how do we maintain clarity on the ownership of copyright in AI generated content, right? Let me present some solutions to you. First of all, number one, AI apps must have very clear and unambiguous terms, right? the terms must also be clearly laying out who the author of the AI generated content is, right? So that is 2 points. And number 3, the terms and conditions must be applicable across jurisdictions. Broadly, while country-wise versions may also be developed, but there may be significant difference in laws. The terms and conditions must be such that they can be uniformly applied across different jurisdictions, right? And you can also mold them and have different country-wise terms and conditions. That is also completely fine. And number 4, I would say the indemnity clauses for AI-generated content must be very robust, right? They must indemnify or hold free from liability, uh, you know, the creators of that content or the app itself to the largest extent possible, right? So basically, I'm saying that the terms and conditions should minimize liability as far as possible, while still holding people accountable or the AI apps accountable. So, as a lawyer who practices in IP, tech, and commercial laws, I can personally vouch that the commercial implications of a lack of clarity on ownership of AI generated content can be quite serious, right? And this is because the risks of infringement lead to serious legal liability, which can lead to the imposition of heavy damages by courts, right? And licensing also becomes more difficult because if it's not clear who the owner of the content is, then licensing it and making revenue from it becomes even more difficult, right? So it is thus very important to seek proper legal counsel and take proper legal advice, have proper terms and conditions and systems in place for both AI companies and the creators of AI content to be able to maximize revenue from it without falling into legal trouble and complicating things for themselves and have heavy costs and penalties imposed on them. So I hope that you liked today's episode and found it helpful. As a lawyer who practices in IP and tech laws in both India and also consults in other countries, I'm always fascinated by all the developments that we are seeing in IP and tech laws and things like AI, data privacy, and all these emerging new fields. And, there's so much to do, so much advisory, so much, having proper contracts in place, advising people on disputes, ensuring navigating disputes. So it's an exciting time, but as a lawyer, it's what I really want to do is for people to be in a good position when they're making their commercial decisions, to not have to worry about legal implications. And that's why the spreading this legal awareness on new things like AI is so important, because it really helps anybody who's listening out there, anyone who's invested heavily into AI, anyone who's running an AI company or a creator. At least they should know about their legal rights and possible implications, so that they can just focus on the business side of things. Thank you everyone for listening in, and I hope to see you soon.